On to. Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this live legal education content, and today may be the day I earn your subscription. For today's live coverage, we are going to start our coverage of United States of America versus Texas. And I have a feeling that we will be following this case throughout, because the bill, as I've commented before, regardless of what you think about abortion, the bill itself is a work of legal masterpiece. You might think it's evil, you might think it's good, but it's hard not to deny it's brilliant in its construction, in the way it's trying to solve problems. The legislature knows they have problems, they're trying to avoid those problems, and they have constructed a bill that attempts to and does a better job than anything that we've ever seen before. Even the Supreme Court, in its own denial of the private cause of action, said in its sort of summary disposition, where they said they're not going to overrule the Fifth Circuit, which is still considering that issue, said that this presents new and novel issues, new procedural issues, and presents a structure that we've not really seen before. So the Supreme Court's initial impression is much the same as my impression. This is maybe cobbling together ideas we've seen before, but we've never seen them really put together in this collective manifestation. And it is a work of technical brilliance. So we're going to cover this probably throughout, because the legal arguments should be incredibly informative from a legal education perspective, because we'll get to see people who wrote the law in trying to anticipate all this stuff, and we'll see the Department of Justice trying to find the holes. So it might be a really great legal battle, and we'll learn a lot along the way. So it should be really, really educational, no matter which way it comes out in the end. So that's really exciting. So we're going to start our coverage today with the complaint from the United States of America versus the state of Texas. So we will get started in that, and it should be really, really interesting. So let's go ahead and get started. Okay, so the first thing that's of interest is we are in the Austin division of the Western District of Texas, which is great news for me, because it means if there are actually hearings in this that happen in person, I can attend them. That's nice news. And it's also interesting for a slightly interesting technical reason, which I was trying to find out the answer to, and there doesn't appear to be an answer. But the U.S. Supreme Court also has original jurisdiction in a case between the United States and states. It's non-exclusive, like it would be in a state versus state. So in the case of state versus state, you have to file in the U.S. Supreme Court. It's the U.S. Supreme Court or bust. In the case of the United States versus a state, you can file in the United States Supreme Court or not. And that made me wonder. I wonder if the state of Texas can force this into the United States Supreme Court right away if they wanted to. And I couldn't find any law on the issue. And there was nothing in the Supreme Court rules regarding the issue. So maybe it's never come up ever. So I've come up with an idea. Can Texas force this in the U.S. Supreme Court? Now, presumably, because the U.S. Supreme Court has concurrent original jurisdiction, they could always say no, go back to they could refuse it. But can Texas try? There is case law that says a state cannot sue the United States in the federal courts unless the federal government gives consent, but they presumably just did by suing Texas. So I was wondering, okay, can Texas turn this around and file this themselves in the form of Texas versus the United States as an original action before the U.S. Supreme Court and try to preempt the whole thing? That'd be hilarious. Or could they file, I guess, what we would call a removal from the district court to the Supreme Court and have the trial there? I don't know the answers to any of these questions, because there's not a lot of cases with United States versus a state, surprisingly enough. So maybe we'll get this to the Supreme Court sooner rather than later, depending on a whole bunch of things. But that's speculation for another time. At least for the moment, though, it's sitting at the federal district court in Austin. Okay. So here is what the United States wants to say. It is settled law that a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability. citing Planned Parenthood. This is correct. Planned Parenthood versus Casey is the dominant case on point. Everyone talks about Roe versus Wade. Probably should talk about it a little bit less, because Planned Parenthood versus Casey is the dominant case on point. And Planned Parenthood versus Casey set the line at viability. So, yeah, that's the controlling case in this area. The Supreme Court has said that Texas has done just that. Well, that's for sure. Fetal heartbreak comes well before viability. That much we know for sure. It has enacted a statute banning nearly all abortions in the state after 6 weeks, months before a pregnancy is viable. Fair enough. I think the record right now, I'm trying to remember, is it 22 weeks and change or 24 weeks and change? It's something like that. But yeah, heartbeat can be at 6 weeks, and viability is either 22 weeks and change or 24 weeks and change. I forget what the record is, but something like that. So yeah. Texas has enacted ASB 5 in open defiance of the Constitution. The statute prohibits most pre-viability abortions, even in exceptional cases, except for, of course, medical necessity, which at 6 weeks, I'm not even sure what that would be, but okay. It also prohibits any effort to aid, or indeed any intent to aid, the doctors who provide these services to women or to the women who seek to exercise. Yeah, so you can't sue the woman directly, but you can sue anyone who assists, including the doctors, and including anyone else who has knowledge of what the woman is doing and assists. So you can't just sue the Uber driver because the Uber driver drove you. You'd have to prove that the Uber driver knew the reason you were going there. And Planned Parenthood does do things other than that, so merely driving them is not enough. Because SB 8 clearly violates the United States Constitution, Texas adopted an unprecedented scheme to insulate the state from responsibility. Yeah, I think we have, and then this is exactly to Chief Justice Roberts' point. This is kind of new in its construction. It's trying to do something that hasn't really been done before, and making the statute hard to challenge in court. They sure try. Instead of relying on the state's executive branch to enforce the law, as would be the norm, that's how laws usually get enforced, the state has deputized ordinary citizens to serve as bounty hunters, who are statutorily authorized to recover at least $10,000 per claim from individuals who facilitate the woman's exercise. Again, perhaps being clever, trying to avoid some issues, you can't sue the woman directly. So you can only sue the people that facilitate it, which is an interesting approach. And Texas has mandated state judicial officers enforce its unconstitutional attack by requiring them to dispense remedies that undeniably burn this right. Reasonable. It takes little imagination to discern Texas's goals, to make it too risky for abortion clinics to operate in the state, or too expensive, thereby preventing women throughout Texas from exercising their rights, while simultaneously thwarting review. That is what Texas is trying to do. They're trying to end abortion and prevent the courts from hearing it. Thus far, the law has stated it had its desired effect. To date, abortion providers have ceased providing services prohibited by the law, leaving women in Texas unacceptably and unconstitutionally deprived of these services. Yet, despite this flagrant deprivation of rights, SB 8 remains in effect. Yeah, I mean, it's interesting, I suppose, that the abortion clinics, trying to mitigate their liability, have refused to go forward. I mean, there's no criminal exposure, it's just civil exposure, but I suppose they don't want even that, so okay. The United States has authority and responsibility to ensure Texas cannot evade its obligations and deprive individuals of their rights by adopting a scheme specifically designed to evade traditional mechanisms of review. That's exactly what they're trying to do, right? They're trying to avoid all the typical mechanisms, right? They're trying to do all those things because, like, well, even Ex parte Young, which is the go-to case for this kind of thing, right? Even Ex parte Young, which says that you can sue a state when it's violating federal law, says you can't sue the judiciary or I apologize, you can't get injunctions against the judiciary of a state. So even Ex parte Young, which says the federal government, well, not necessarily the federal government, but an entity can sue a state, says you can't get injunctions against the courts. So they thought about all that, right? They tried to prevent all that. And how do you get an injunction Who do you get an injunction against? You can't get an injunction against any executive branch official. They don't have any power to enforce the law. So who do you get an injunction against? Everybody? Like every citizen? We're going to cover that in a second, too, which raises its own questions, by the way. The federal government therefore brings a suit against Texas to obtain declaration that it's invalid, to enjoin its enforcement, and protect the rights that Texas has violated. The government also brings suit to protect other federal interests that SB 8 impairs. SB 8 conflicts with federal law by purporting to prohibit federal agencies from carrying out their responsibilities under federal law to relate to abortion responsibilities. Yeah, that definitely is not going to fly. If you have actual federal employees, or even contractors for that matter, who are doing things related specifically to their job, and you try to sue those people, that's a no-go. You can't sue those people. The federal government has sovereign immunity, right? So you can't sue a federal official who, in the course of their employment, is doing something that would violate SB 8, because they're a separate, independent sovereign. So if you have a federal entity who somehow is, in the course of their employment, doing something that would be facilitating SB 8, and you try to sue them, you're going to have a bad time. That's not going to fly. So they're certainly right about that. Because SB 8 does not contain any exceptions for cases of rape or incest, which, to my understanding, is very, very unlikely or very rare, less than 1%, its terms purport to prohibit the federal government and its employees and agents from performing, funding, reimbursing, or facilitating abortion. You can't stop. The state government cannot stop the federal government from acting. That much is true. I mean, undeniably. Moreover, SB 8's unconstitutionally broad terms purport to subject federal employees and non-governmental partners who carry those responsibilities to civil liability and penalties. Yeah, that's a no-go. The United States government therefore seeks declaratory judgment that SB 8 is invalid under Supremacy Clause and the 14th Amendment, is preempted by federal law, and violates the doctrine of intergovernmental immunity. The United States also seeks preliminary and permanent injunction against Texas, including officers, employees, agents, and, this is an interesting aspect, including private parties who would bring suit under the law. And they actually say that also in the party's description. So what is the state of Texas? The federal government describes the state of Texas as the following. The state of Texas includes all of its officers, employees, and agents, including private parties who would bring suit under SB 8. So the state of Texas, including all the governmental actors, sure, but including all the private parties who would bring suit. This raises a question in my mind immediately. Because, first of all, the scope of SB 8 appears to allow anyone, by its own terms at least, allows anyone to sue. So private parties is potentially anyone in the world, at least the way I read SB 8, unless I missed something. Anyone can sue anywhere. So apparently that's everyone. Or if even maybe everyone in Texas. Or everyone in the United States or something. So you want an injunction, or you want to sue the state of Texas. You want to sue the Attorney General as representing the state of Texas, fine. But does the Attorney General of Texas really represent me? Because I live in Texas. I'm not part of the state. So my immediate question is, does this really work? I did notice in the lawsuit, when they gave service of process, they gave service to the Attorney General. But if this is going to try to enjoin private parties from acting, question, don't those private parties have to be served with process? So that's my immediate question. So I was talking to Nick Rakita about this on the phone. And I was like, there's a small part of me that wants to troll Merrick Garland and show up as a special appearance, as an intervener, and say, hey, wait a second, I'm an interested party in this apparently now, and I haven't been served. Also, because it affects private persons. You know who else is a private person? Merrick Garland in his private capacity. He's not a state official. He's a federal official. So technically speaking, right, Merrick Garland himself is a private official. So if I really want to be a real jerk and really want to shitpost on a federal court, I could be like, yeah, Merrick Garland hasn't been served in his personal capacity, and he's potentially a private person, and yeah, so he needs to be served. That's a lot of, so there's a small part of me that wants to go shitpost on a federal court. Anyways, it's one way to get the channel's name in the news. Uncivil Law LLC files the following. Oh, joy. All right, so let's talk about the constitutional right to abortions. Nearly 50 years ago, the Supreme Court held a constitution protects a woman's decision whether or not to terminate the pregnancy, citing Roe. 30 years ago, they reaffirmed the most central principle, a woman's right to terminate, in a case called June Medical Services. Casey confirmed Roe's essential holding, recognizing a woman's right to choose to have an abortion before viability and obtain it without undue influence from the state, whose pre-viability interests are not strong enough to support prohibition or imposition of substantial obstacles to elective procedure. State laws that prohibit abortion prior to viability or impose an undue burden violate the Due Process Clause of the 14th Amendment, which is the basis for the right of abortion. Somehow, I'm not a constitutional scholar. Oh wait, yes I am, and as has been noted before, I have a hard time believing that when the founders wrote the Bill of Rights or they wrote the 14th Amendment, that anyone had abortion anywhere in their mind when they were writing it. Having a difficult time believing that. The words obviously aren't there. Having a difficult time believing that was one of those unspoken rights that maybe like the 9th Amendment was talking about or something. Not really sure that was, I'm not sure about that one on that, yeah. Casey confirmed Roe's essential holding. State laws that prohibit abortion prior to viability or impose an undue burden violate the law. Okay, yeah. The interests of the United States. Whereas here a state seeks to strip individuals of their ability to challenge state action that indisputably violates their federal rights, the United States has a profound sovereign interest in ensuring that those rights remain redeemable in federal court. The United States may sue to challenge a conduct that affects the public at large. Every government entrusted by the very terms of it being with powers and duties to be exercised and discharged for general welfare has the right to apply to its own courts for any proper assistance. In re debs. This is also a holding of a United States versus Texas from around the same time period, which was one of the cases that said that there was original jurisdiction in the U.S. Supreme Court, incidentally. The prerogative of the United States to seek injunction and declaratory relief has long been recognized. The Constitution cannot mean to give individuals standing to attack state action inconsistent with their rights, but deny United States standing when the state jeopardizes the rights of the nation. I mean, probably that's true. The United States, therefore, may sue to vindicate the rights of individuals when the state infringes or rights protected by the Constitution. And such an effort is particularly warranted, whereas here, private citizens are, by design, substantially burdened in vindicating their own rights. In light of the attempt by Texas to strip its own citizens of the ability to invoke the power of federal courts because of the standing issues, right? Because no government, one of the reasons they say that is because no government officials being involved. So you can't sue in federal court because there's no one to sue. Like Ex parte Young would say you can sue the government, but they're not doing anything. So, and there's so the U.S. Supreme Court, or apologize, the U.S. government is trying to come in to solve the problem. Ex parte Young will be making an appearance, not in this document probably, but it will definitely be making an opinion in this case, appearance in this case at some point. In line with the attempt to strip citizens of the power to vindicate their rights, the United States not only has a quasi-sovereign interest in the health and well-being of its residents in general, but also a quasi-sovereign interest in not being discriminated, denying rightful status within the system. Nate the lawyer is here. Hello, Nate the lawyer. We are trying to pick apart the issues of the case. I did note, Nate, that there is a issue here that seems to be, I'm not sure exactly what the answer is, but they defined the state of Texas to include all private persons who might be able to sue under this law. And I'm thinking to myself, wait a second, do I have to get service of process? And then I had this latent thought of maybe I should shitpost before the United States federal court and make a special appearance and bitch because I didn't get service because I'm apparently an interested party. So, yeah, and then we had an idea of technically Merrick Garland in his personal capacity is also technically a individual who could sue. So we could also say, by the way, also Merrick Garland hasn't gotten service of his own lawsuit, which is hilarious. So what do we want to shitpost before a federal court is currently up for debate? The Supreme Court of the United States mandates that the Constitution and laws of the United States shall be made in pursuance of the supreme law. A state law is invalid if, among other things, it stands as an obstacle to accomplishment and execution of full purposes and objectives of Congress, or if it directly regulates the activities of the federal government. Intergovernmental immunity. The doctrine of intergovernmental immunity arises from the Supremacy Clause of the U.S. Constitution and reflects the principles that states have no power to retard, impede, burden, or in any manner control the operations of laws enacted by Congress to carry into effect powers vested in the national government. Well, that's definitely true insofar as, the state governments can't nullify federal law. There's a whole civil war about that one. And they definitely can't prevent federal actors from acting. So that's definitely true. All those things. States may not seek to directly regulate the performance of federal government by regulating its contractors. Yeah, that's true. A federally owned facility performing federal function is shielded from regulation, even though it's carried out by private contractors. Yeah, they're not technically employees, but they're working for the federal government. So, close enough. I think that's got to be right. Wholly unconstitutional state law that directly interferes with function of federal government by mandating the ways it renders that service. Yeah, so to the extent that Texas is trying to regulate, prohibit, interfere with, or otherwise control in any respect any federal government official, whether employee or contractor, from performing their duties within the scope of their employment, Texas is going to have a bad time. Texas is going to have a bad time. Yeah, you can't do that. So regardless of how this lawsuit itself comes out, so even assuming this lawsuit for some reason goes away, the first time that anyone tries to sue a federal employee who was working in the course of their employment, it's game over for suing federal employees. You can't do that. You can't interfere with the federal government employees. That's no. So let's discuss a little bit about how the law came into place. Yeah. SB 8 bans abortions performed by a licensed physician in the state of Texas if cardiac activity has been detected in an embryo or fetus. Specifically, the law provides that a physician may not knowingly perform or induce abortion if they detect a fetal heartbeat. And then they define fetal heartbeat as heart activity or steady and rhythmic contraction of the heart within the gestational sac, which, seems like a reasonable place to define heart. An ultrasound can typically detect cardiac motion beginning at approximately 6 weeks as measured from the first day of the patient's last menstrual period. But an embryo is not viable at 6 weeks, and many women do not even know that they're pregnant at 6 weeks. Test early, test often? I don't know. That's a joke, by the way. I have to say that because every time I make a joke like that, someone in the YouTube comments then says, "What a misogynist." It's a joke. And now I have to explain the jokes. That's just great. A fetus is generally considered viable when there's a reasonable likelihood of survival outside the womb, with or without artificial support, which is not usually until 24 weeks. Yeah, it's something like that. SB 8 contains no exceptions for pregnancies that result from rape, sexual abuse, or incest, which is rare to the point of vanishing. That's not the vast majority of abortions. Or for pregnancies involving a fetal defect incompatible with life after birth. The law provides an exception only for an undefined medical emergency that prevents compliance. The prohibitions in SB 8 apply to anyone who performs or induces a prohibited abortion, anyone who knowingly aids or abets the performance. That's the key word there, knowingly. You have to know that you're doing it. And even anyone who intends to do it. Under the statute, aiding and abetting includes paying or reimbursing costs of an abortion through insurance or otherwise, if you know that's what you're doing. SB 8 limits the defenses available to defendants and subjects them to fee-shifting regimes skewed in favor of claimants. It sure does. In particular, the law includes an affirmative defense that's available to a limited class of defendants if they can demonstrate the relief would impose undue burden on a particular woman or group of women seeking an abortion, which is really nice touch from Texas. It's a really nice touch because one of the things you can't do is impose an undue burden, according to the Supreme Court, right? So they say, well, it's an affirmative defense, right? If it's an undue burden, then you can say, then you get relief from any imposition. So so Texas is basically saying this only goes as far as undue burden would allow, which arguably is in compliance with the law, right? You have to prove undue burden. It's on you to prove it. But if you can do it, you get relief. So, okay. That limited defense is inconsistent with the unbroken line of Supreme Court cases that prohibits abortion prior to availability without regard to undue burden test. No, that's not quite right. And even if the undue burden framework were appropriate, the affirmative defense functionally distorts the test by, among other things, limiting the scope of evidence on which a defendant may rely and attempting to create new rules of construction and severability solely for the laws and regulations. Yeah, you can prohibit abortion prior to viability. Well, I don't know. Maybe the key word here is prohibiting. Maybe the key word there is prohibiting. Because you can't have an undue burden. And maybe prohibition is definitionally undue. So maybe that's where they're going. But yeah, prior to viability, undue burden is the test. After viability, the state can outright ban it under Casey. So yeah. And so then they try to say, well, what is or is not an undue burden? They're trying to define it by state law, which might be completely permissible. So the state is the state might very well try to argue that their law is completely compatible with the Supreme Court's decision, right? It's an affirmative defense, so you have to prove it. It's on you to prove it. But if you can prove it's an undue burden, because also we're not trying to stop you in advance, right? You can't get the injunction in advance. So the people who drafted this, as I pointed out before, try to think of everything. Right? They're trying to think of everything. You can't get an injunction. Like, you can't get an injunction against a woman who is going to do this. The law doesn't allow for that. You can only do it after it's done. And then you can go after anyone who helped or intended to help. But only after it's done. And you can't go after the woman herself. And the people you can go after, they can't go after if it would be an undue burden. So the Supreme Court, the statute tries to cover all this. So Texas can make a non-trivial argument. Their statute is actually compatible with Casey. It's like, yeah, we're not trying to stop you in advance. We're not trying to make you prove it in advance. And if it was an undue burden, if you can show it's undue burden, you're relieved of any liability. So, Texas can at least make a try at it. They're trying. They thought of a lot of things, man. Additionally, the defendants in these enforcement actions are prohibited from raising other defenses enumerated in law, including that they believe the law was unconstitutional. Right. So now notice clearly, again, I made this point in my analysis. They can argue the law is constitutional. That is a defense. But they can't argue their mere belief in it, which makes total logical sense. Like, a normal person wouldn't be able to do that either. Like, if I broke a law, pick your law of choice. It doesn't really matter. If I broke a law, I couldn't go into court and say I'm exempt from that law because I believed it was unconstitutional. This is basically what every sovereign citizen does, essentially, right? This law doesn't apply to me. I think it's unconstitutional, right? So your belief in unconstitutionality doesn't work. The fact of its unconstitutionality does. So what I can't do is go into court and say, the law doesn't apply to me because I believe it's unconstitutional. The law doesn't apply to me because it is unconstitutional. Now we have a colorable argument. Right? Now we have to have a discussion about whether it's constitutional or not. It's not about the belief. It's about the reality. So yeah, you can't argue your mere belief it's unconstitutional, which isn't a defense to any law ever that I'm aware of, that they relied on a court decision later overturned that was in place at the time of the acts underlying the suit. That could be a problem. Well, but if it's overturned by a higher court, right, then the underlying decision didn't exist, so And also it's in a civil context, so we don't have the ex post facto problem. Or that the patient consented. Yeah, that the patient consent's irrelevant. Right. If they didn't consent, we'd have a whole other host of problems. SB8 also states that the defendants may not rely on non-mutual issue preclusion or claim preclusion, which basically essentially makes every case non-precedential. So multiple people can sue over the same causes of action. Or any other state or federal court decision that's not binding on the court in which the action was brought. Which basically says if there's a court of appeal, say, for example, in Texas, because Texas has multiple courts of appeal, if there's a court of appeal that says one thing, but you're not within that jurisdiction, you can't rely on that as a basis. You have to have one in your own chain of command. So like trying to sever everything out, right? Trying to, which incidentally is perfectly reasonable as far as courts of appeal go, because the federal government does that with its courts of appeal. All the courts of appeal decisions are technically non-binding on all the other courts of appeal. They're only informative, right? So you can't simply say, if you're in the First Circuit, you can't simply say, well, the Ninth Circuit has ruled this way, and the Eighth Circuit's ruled this way, and the Seventh Circuit's ruled this way, and the Sixth Circuit's ruled that way. Therefore, I win. It's you have to say why the First Circuit should agree with all that, right? You can't say, well, they all said it, so I'm there. So Texas is basically trying to do the same thing. All of its courts of appeal with respect to this issue only control the geography which they control, which, seems kind of reasonable unto itself. Fair enough. SB8 deputizes private parties as state actors. So this is going to be where they're going to try to go. So they're going to say that the private parties are in fact state actors. Okay. Now let me give you some ideas of what state action by private parties would look like. Basically, when a private party is so intertwined with the state, they can be treated as a state actor. So I'll give you the classic example. The classic example is a police officer who is frustrated and wants to search a house, and they can't get a warrant. Right? They can't get a warrant. They're sad. They can't get a warrant, and they really want to search that house. Now, this police officer is a knowledgeable police officer, so they know that if a private party were to do it, right, then that's not government action. So, random guy for reasons, maybe he's a private investigator, whatever. He's a private investigator. He breaks into your house. He conducts a search. Now, you might be able to sue him for any number of things, but if that evidence tries to be admitted in court, you're hosed. Right? You can sue him for trespass. You can sue him for all kinds of stuff, but you can't suppress because he's not a governmental actor. So no. So this police officer knows all that and says, well, geez, if this private detective were to do it, then, it would be okay. So the police detective hires the private investigator. No, that doesn't work, right? No, that doesn't work. At that point, you're a state actor. Incidentally, this is why Batman is a state actor. Batman is totally a state actor. Yeah, Batman is absolutely a state actor and is totally suable under 1983, and Gotham is suable under Mondale. So let's do some Batman analysis while we're at it. Yeah, so Batman is a private individual who is gone into the night and fights crime. Unfortunately, he has pretty close ties to the police department. There's the bat signal. There's the bat phone. He talks to the commissioner of police on rooftops on a not infrequent basis. He's totally a state actor. So that means, by the way, the Fourth Amendment applies to Batman. All that evidence that he finds totally getting excluded. He didn't have a warrant. He beats up on those criminals quite a lot. Eighth Amendment problems. Eighth Amendment problems for days. The city has a policy in place to assist the Batman. See, for example, bat phone and bat signal. Mondale, you can sue the city of Gotham for its illegal assistance of Batman under 1983. All that evidence, all that work from Batman is going down in flames, man. And the city is liable for millions of dollars. Two-Face and the Joker are going to have one hell of a laugh at the city of Gotham and Batman's expense. Batman's going down. That's definitely a thing that's happening. Okay. Now we've talked about the Batman and abortion in the same sentence. How much fun is that? Did you know that Batman was relevant to abortion? The more you know. Okay, so anyways, now that we've gotten that, the state over here has basically said, hey, private individuals, you can enforce our state law. So we have to decide if that's intertwined enough to comprise state action. Probably, but fun times. Yeah. Oh, Batman's getting qualified immunity? Oh, hell no, he's not. No, hell no, he's not. No way is Batman getting qualified immunity. When you're doing state action doctrine, you don't get special analysis. So the same, once you determine he's a state actor, he's in the same analysis as the cop is, right? When you're trying to determine what rights are clearly established, you don't say at this point, he's just a police officer, okay? He's a police officer. He calls himself the world's greatest detective. He's now a police detective. So yeah, when you're trying to do your 1983 analysis, the fact is Batman is irrelevant. He's a police detective. He busts into house all the times and he quasi tortures people, beats them up to get all kinds of confessions. You're right. He uses physical restraints. He never gives anyone Miranda. Batman is a 1983 Fourth Amendment disaster area. Yeah, he's a total disaster area. So anyways, going back to abortion, the bat abortion. Going back to bat abortion, now that the state of Texas has made everyone a actor, made everyone what you call a private attorney general, because what does the attorney general do? They enforce state law. So that's the public attorney general. So congratulations, literally everyone. You're now a private attorney general. Probably state action enough. Yeah. Yeah. So in a transparent effort to evade constitutional scrutiny, is it because the phone and city or light provided? It's not necessarily because they provided them. It's because they used them for the purpose of signaling the Batman. Doesn't really matter who provided them. Doesn't matter if the city created it. Doesn't matter if Batman provided it. Doesn't matter if it fell off a truck. The city uses it with the purpose and design and as part of a policy to contact the Batman. They're hosed. They're totally hosed. Yeah. The courts are going to enjoin the shit out of this guy. SB8 prohibits state and local government officials and their employees from enforcing the statute. In their place, SB8 empowers any person to file suit against anyone who performs a prohibited abortion, aids or abets such abortion, or intends to do any of those things. A successful claimant can obtain an injunction that prevents the defendant from engaging in those activities and is entitled to at least $10,000. And it doesn't set a maximum. The statute assigns enforcement authority from private individuals through civil litigation in state court as a means of evading lawsuits challenging this authority. Indeed, if SB 8 were specifically designed to invade ordinary constitutional review, specifically law bars its own enforcement by public agencies, but creates a private cause of action that requires state courts to grant injunctive relief and statutory damages for constitutionally protected activity. You know, one of the things I could do is I could do like a quasi-series where I go through Batman, the animated series, which is still the best cartoon ever, Come Fight Me. And I could go through that and I could point out like all the violations of law that are occurring. Because so many. We could start drafting complaints against the Batman. The statute enforces law enforcement to private individuals. By the way, this is also just a great gig for any attorney who wants to represent all the people, all the criminals of Batman. So I'd like to officially offer my services as a lawyer. Have you been injured by the Batman? Many people have been injured by the Batman in all kinds of ways. Has your car been stolen? Has your house been broken into? Have you been hurt or injured in an accident from the Batman? If so, call Uncivil Law. I work for you, and I don't get paid unless we win. Uncivil Law, here to fight for your rights against the deprivation of the Batman. I'm available. The statute assigns enforcement authority to private individuals through civil litigation in state courts as a means of evading these lawsuits. Indeed, SB 8 was specifically designed to evade ordinary constitutional review. Specifically, the law bars its own enforcement actions by public officials, but creates a private law of actions that require state courts to grant injunctive relief for statutory damages. This intent has been unmistakably revealed in public statements by the law's architects and champions. For example, legislative director of Texas's Right to Life stated that one of the main motivations was to stymie judicial review. Well, anyone who can read law can figure that much out, but yeah. Moreover, one of the attorneys principally involved in advising the state on the law recently offered a similar observation about the law's bearing on SB 8's private enforcement characteristic. It's practically impossible to bring a pre-enforcement challenge to statutes that establish private rights of actions because the litigants who enforce the statute are hard to identify until they actually bring suit. But they're really state actors, right? I feel like I should get service somewhere. And Senator Brian Hughes, one of the principal architects of SB 8 in the Texas legislature, removed all doubts about this purpose when he informed reporters that SB 8's structure was intended to avoid the fate of other heartbeat bills. Yeah, they learned from the misfortune of others, right? So, yeah. The senator was quoted as succinctly stating the point, "We're going to find a way to pass this heartbeat bill that was going to be upheld." Senator Hughes elsewhere deemed the statute a very elegant use of the judicial system. It's elegant. Whether or not it will succeed in the end, it is undeniably elegant. You can't sue the Batman. How can you file a complaint? Well, no problem, actually. At least under the federal rules, and I'm pretty sure any state rules, well, it's federal law because it's 1983. No problem. So I can't find any other way to effect service. No problem. I just publish it in a newspaper of large enough volume for a certain period of time. You ever go into the classified sections of newspapers and they have legal notices? You ever wonder why they're there? Yeah. So, yeah, that's how you do it. It's like, well, I can't serve any other way, so to the classifieds of the newspaper. So the Gotham newspaper is going to get a running ad in their classifieds for the notice to the Batman that you're being sued. There's your service of process. Easy. Easy peasy. Also, because we have the bat signal, I'm just saying, we have the bat signal. So we could turn on so a process server, this is the greatest process server ever. A process server could turn on the signal. And then when the Batman shows up, says, you're being served. And even if he flies away, that qualifies, right? That qualifies. So he's been served. How about that? The process server turns on the bat signal or uses the bat phone. We've got an emergency down for the police precinct. You got to show up right away. Where's the emergency? Here's your blue back. Go choke on it. While prior service efforts to unduly burden state access to abortion clinics rely primarily on state executive action, it's doubtlessly true the state may act through different agencies, including legislative, executive, or judicial authorities, and there are prohibitions of the amendments to extend all actions of the state in denying equal protection of the laws, whether it be actions by one of those agents or another. Awaiting monetary relief that SB 8 authorizes to plaintiffs who need not demonstrate any injury or other connection to underlying abortion procedure constitutes state activity designed to violate the 14th Amendment. I mean, I feel like this has got to be true because there's no private action, there's no real private harm. This is all to enforce state law. So yeah. $20 from Peter Bemis says, Kurt, want to make your channel grow? Hire an animator and make a Sue the Batman ad. This is a great suggestion. I could work on a script. And I could make a Sue the Batman ad. I love this suggestion very much, Peter. To Fiverr. 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 Okay. Awaiting other monetary relief that the authorizes to plaintiffs who need not demonstrate any injury to other connection to the underlying procedure constitutes state activity designed to violate the 14th Amendment. The actions of state courts and of judicial officers in their official capacities is to be regarded as action of the state within the meaning of the 14th Amendment, is a proposition which has long been established by the decisions of the Supreme Court. Is a newspaper required to publish them? No. But it's money. They're not required to, but it's money. So yeah, I guess the Gotham Gazette or whatever might not publish them, but it just has to be a widely circulated newspaper. How about the New York Times? I'm going to make the money back. I mean, running a legal ad in the New York Times is going to get expensive and all, but still, it's the Batman. Dollar bill, y'all. I don't see a problem on that one. Thus, while Texas has gone to unprecedented lengths to cloak its attack, cloak like the Batman, its constitutionally protected rights behind a nominally private cause of action has nonetheless compelled the judicial branch to serve an enforcer's role. State action, as that phrase has been understood, refers to exertions of state power. I think that's fair. Under the state action doctrine, private actors may also be found to be functions of agents or the arms of the state itself. State action may be found if seemingly private behavior may be fairly treated as that of the state. I think that's probably right. Even if I get a default action against the Batman, how do I execute if you don't know he's Bruce Wayne? I guess, I don't know. Impound his car? Once it's out on the streets? Put a boot on his car? Some police tape on it? Yeah, that's fine. How do I collect? Well, I get what's called a writ of attachment. I get a writ of attachment in order to attach to all of his property. And anytime I find the bat fill in the blank, I seize it and sell it at sale. And yeah. So no problem. No problem. We can do this. Under the state action doctrine, private actors may also be found if functions or arms of the state itself and thus bound by the Constitution. The Supreme Court has deemed individuals to be state actors when they exercise powers traditionally exclusively reserved for the state. SB 8 vests individuals with law enforcement authority, a power traditionally reserved to the sovereign, in a manner that appears to be unprecedented. Among other things, SB 8 does so by providing individuals with unsupervised authority to police violations of the law and enabling them to obtain civil penalties against anyone in the state without showing a personal injury. Gotham is Chicago? I don't think that's true, is it? These individuals are also state actors to the extent they're significantly involved in conduct that would be unconstitutional if engaged in the state by Texas itself has sanctioned their conduct. Finding state action where law authorized racial discrimination in the housing market. State establishment of primary system made a private party that set up a primary and agency of the state. I think you're probably there under state agency doctrine. SB implicates this doctrine by expressly authorizing and empowering individuals to engage in conduct that violates the rights of women throughout Texas, a manner in which the state itself would not be able to engage. Yeah, I think Merrick Garland probably has state action about right. It'll be really interesting to see what the state of Texas says in response, but this looks right. Yeah, because there's no injury to the plaintiff because you don't have to show any standing otherwise, right? You don't have to show a harm to you of any kind. It's just any person. So yeah, and the harm is to the law rather than to you, and it's the state's law. So yeah, you're suing for the state's harm. It's state action. I think you're there. It'll be interesting to see if Texas has a really brilliant reply to deal with this. But yeah, I think Merrick Garland's got that one right. Gotham is Chicago. Now we have a debate about where Gotham is. Alexander says the judges in Gotham are so corrupt you'd lose at a motion to dismiss. Aha, but that's one of the reasons I'm suing in federal court, right, for 1983. I'm suing the Batman federally. 1983. 1983. Yeah, so the federal judges will save me. This is the first I've ever heard that Gotham is Chicago. This is the first I've ever heard this, so. SB 8 affects interstate commerce. Well, everything affects interstate commerce, so yeah. Now, the federal government can regulate interstate commerce, so the mere fact, well, unless we're going to go with the Dormant Commerce Clause doctrine, so let's give that a shot. By stripping women of their constitutional rights to certain activities or services in Texas, as well as outlawing many commercial services that provide these services and aid women in seeking the services, SB 8 forces women who wish to obtain these services to travel out of Texas to other states in order to exercise the rights and hinders Batman businesses and nonprofits engaged in commercial activity. Indeed, the law has already had its effect, as clinics in Oklahoma, Louisiana, New Mexico, Colorado, and Kansas are being inundated with a surge of pregnant people. I do like that someone said pregnant people. This is one of my new least favorite things from the left. And makes me, it's depressing when the left opens their mouth and it makes me more right-wing. Because we have this whole idea of pregnant people and menstruating people. And men can become pregnant too. I do like the fact that, they used to say that abortion was a woman's health issue. And they used to say that men shouldn't express opinions about abortion because men can't get pregnant. Well, apparently that's not true. Apparently men can get pregnant. Apparently it's no longer a women's health issue. So that was neat. So apparently, because I'm a man and men can get pregnant, I now have as much moral claim to have an opinion about abortion as anyone else. Yeah, that's great news. One clinic in Oklahoma reported that after SB 8 went into effect, the number of calls it received from Texans increased from approximately 3 to 5 calls a day to 50 and 55. The article makes clear that proponents of SB 8 are aware of women crossing state lines. Before SB 8 took effect, most Texas women had access to a clinic within a 24-mile round trip of their home. Now they'll have to travel 496 miles round trip on average to obtain an out-of-state abortion. Yeah. While the United States is obligated to provide constitutional abortion services to SB 8 outlaws, I don't think that's necessarily true. I don't think the United States is obligated to provide the services. I think that's wrong. Yeah, that's wrong. Just because you have a constitutional right to something doesn't mean the government is required to provide it. Most rights are considered negative rights. Yeah. This is an interesting right too, because if abortion is a right, it contrasts in a really fundamental way with every other kind of right in the Constitution. Yeah. If abortion's a right, it contrasts with every other right in the Constitution. Every other right in the Constitution is a negative right. What we mean by a negative right is it prevents people from doing something. A positive right would be something that someone has to do, right? A positive right would be an obligation. Someone has to give you something, right? So a positive right would be, we have a contract. I give you $100. You give me a book. I've already given you the $100. I have a positive right to the book. You must provide me the book. Right? That's a positive right. You have to be provided something. A negative right is you can't do something to me. That's negative. That's what makes it negative. So every other right in the Constitution is a negative right. I have freedom of speech. That's a negative right. The government can't interfere with my freedom of speech, but they don't have to help. Freedom of religion is a negative right. The government can't interfere with my freedom of religion, but they don't have to help. And so forth and so on. Right? But abortion, is that a negative right or is that a positive right? Because they just said that the United States is obligated to provide, which implies that abortion is a positive right, which is weird. Because the Constitution doesn't really do positive rights. The Constitution's mostly just leave me alone. But now they say in paragraph 38, the United States is obligated to provide. So they've just turned abortion into a positive right in the Constitution. This is strange. SB 8 purports to require the United States to refrain from providing those services or relocate women and possibly service providers out of Texas. If they're your service providers, then I think you're probably fine. Similarly, SB 8 purports to require the United States to terminate existing monetary contracts and agreements regarding insurance. Yeah, that's a no-go. If there's government money, that's a no-go. Although it shouldn't be government money because of the Hyde Amendment. I'm not saying it's impossible. I'm not the greatest, expositor of the Hyde Amendment ever, but the Hyde Amendment is an amendment that prohibits the federal government from spending money on abortion. Right? Or more the point, it says, no money provided by the U.S. government can be used for the purposes of abortion. Now, money is fungible, right? So if you give Planned Parenthood $1 million and you say, Planned Parenthood, here's $1 million, you can't spend it on abortion. Well, what does Planned Parenthood do? They say, great, I'm going to take that $1 million and I'm going to use it to pay for, pay for the lease, pay for the electricity, pay for, providing counseling or whatever, right? I'll use that $1 million for something else. And then money I was going to spend for abortion or money I was going to spend for, landlord costs, I no longer have to spend that money, right? So let's create an easy hypothetical. The U.S. government gives you $1 million. It says you can't spend it on abortion. You're a Planned Parenthood clinic. Your lease is $1 million, right? So you were going to spend $1 million on the lease, but the federal government just gave you $1 million, said you can't spend on abortion. So what do? Well, you say, well, okay, I'm going to use that $1 million the U.S. government just gave me to spend for the lease. Oh, look, suddenly I have $1 million free. Whatever will I spend it on, right? So, yeah, the Hyde Amendment says you can't spend money on abortion. So, query how that works exactly in this context. I'm not saying it's impossible. It's just a little odd. It's a point of note. Super chat from Mandalore Y says, if the U.S. is obligated to provide abortions, it's also obligated to give each citizen a standard M16. The Swiss do it. A machine gun in every home, man. What's wrong with that, right? SB 8 further prohibits and then discourages certain interstate commercial transactions involving Texas. For example, SB 8 appears to apply to money transfers in the state of Texas if those funds may facilitate abortion. Thus, SB 8 may apply to insurance companies throughout the United States that cover abortion services provided in violation of statutes. True. As well as banking facilities, transfers of funds to reimburse women. True. SB 8 may also apply to medical device transactions, including out-of-state sellers, including, for example, the sale of equipment that could be used to perform abortions. Well, you wouldn't be able to, as long as it has any other purpose, you don't sell it for the purpose of conducting an abortion. Right? That's how you solve that problem. So as long as it has any other utility, you sell it for that reason. Right? This is for, I don't know, removing polyps or other things. And you'd be fine. You'd be fine. SB 8 irreparably injures the United States. The United States as such? SB 8 injures the United States by depriving women in Texas of their constitutional rights while seeking to prevent them from vindicating those rights in federal court. On September the 1st, SB 8 went into effect prohibiting nearly all abortions. The law prohibits at least 85% of abortions that were previously lawful, which indicates, presumably, that 15% of abortions where women don't usually know they're pregnant. Apparently, 15% of women figured it out. SB 8 unlawfully prohibits women from exercising the constitutional right to pre-viability abortion, including for women in agencies' cares and custodies. SB 8 violates the constitutional right for pre-viability abortion by prohibiting healthcare providers from performing abortions after 6 weeks. To the extent SB 8 could be viewed as only regulating pre-viability abortions. Yeah, okay. Such that the undue standard would apply. Yeah. The law also substantially burns the right by imposing liability, who aid or abet, although it tries to present an affirmative defense to get around that. Under settled precedent, a ban on nearly all abortions after 6 weeks cannot survive constitutional review. I think that's probably right, at least directly. SB 8 attempts to circumvent this rule by implying a distorted version of undue burden. Okay, so this is, all right. So the Merrick Garland over here cites a case for the proposition that it strike down a 6-week ban from the Fifth Circuit, incidentally, so that would be binding authority on Texas. Because cardiac activity can be detected well before a fetus is viable, and that dooms the law. Well, it's a segment from the law, a segment from the decision, so we'll be a little bit skeptical about it. SB 8 attempts to circumvent by applying a distorted version of undue burden, requiring courts to weigh undue burden in every case as part of affirmative defense enforcement context. Well, I mean, undue burden would be fact-specific. I mean, presumably, right? I mean, a lot of things are fact-specific in law, so okay. SB 8 requires persons who are sued to prove that the imposition of injunction, monetary penalties against them will impose a substantial obstacle on patient access to care, and do so without relying on the effect of a award of relief against other defendants or other potential defendants. So you have to do it based on what harm it comes to you. So you can only claim undue burden. So you can only claim undue burden for injunctions against you by citing the harm to you, which seems logical enough, right? It would be a little bit weird for me to say, this is harming another person, and consequently, I have there's a problem there somewhere. Even though practical effect of abortion across the state is a relevant consideration in evaluating the undue burden claims. Is it though? Accordingly, SB 8's undue burden defense does not remedy the law's unconstitutional abortion ban. That's a little conclusory, I'm not so sure about that one. SB 8 harms the United States by seeking to foreclose judicial review of state law that flagrantly infringes constitutional rights of the public at large and seeks to block the injured members of the public from challenging. The United States may sue to vindicate its interests in preventing Texas from affecting it. The president also has a duty to take care the laws be faithfully executed, a duty is carried out by the Attorney General. So far, we have reached the conclusion, at least. Here's the conclusions we have so far reached today. We have so far reached the conclusions that, anything that's going to attempt to prevent a federal government actor from acting is a no-go. So that's definitely not going to fly. You can't stop federal government actors from acting, contractor or not. It's like, Now, whether or not that's ripe or not in this case is an issue, but that's definitely, Then we have this issue about, Texas has tried to define what undue burden is. Which, you'd have to, the law on undue burden is a little bit chaotic. So Texas giving it a go is not the wholly unreasonable. And saying it has to be fact specific. Like many things in the law, like it has to be fact specific to you. It has to be your undue burden. It's an undue burden to you in this case, but not other cases, right? So you could sue me for a lot of things, and depending on the particular facts, you could sue me for ostensibly like the same cause of action. Like, I don't know, how about a nuisance complaint, right? My neighbors are suing me all the time because of various nuisances on my property. And depending on the specific facts of that, and also depending on the specific neighbors, those cases come out differently, right? So a neighbor who's a mile away, maybe not so much, but the neighbor who's next door, maybe. For this kind of nuisance, not that kind of nuisance. That kind of thing, right? So so even though they're all ostensibly nuisance suits, they could be individualizedly evaluated. And they might come out differently, depending on what I'm doing and depending on who the neighbor is. So Texas saying, this has to be individualized, undue burden, and you can only go to the burden to you. Like, it has to impose an undue burden on you. You can't claim someone else's burden. If it's an undue burden to them, then they have a defense, but you have no defense because you have no standing. Plausible. So so Texas's response, I don't know what they're going to do about the fact that that they're going after federal government actors. I don't know what they're going to do about the fact that private individuals are state actors. If they have anything colorable, it'll be really interesting. But I think I think Texas has some at least plausible responses on the undue burden stuff. It's like, we're only allowing people to claim their own undue burden, and whether or not it's undue is going to be fact specific and has to be evaluated individually. So, it's plausible. It's plausible. Excuse me 1 second. All right. SB 8 unconstitutionally restricts the operation of federal government in conflicts with federal law. By prohibiting nearly all abortions in Texas after 6 weeks of pregnancy without exceptions for rape and incest and sexual abuse, SB 8 unconstitutionally conflicts with statutory and constitutional requirements of the federal government. Incidentally, the exceptions for rape, sexual abuse, or incest are kind of irrelevant in the legal analysis because, the medical necessity is relevant. But I don't know of any case off the top of my head which dealt with a right specifically related to rape, sexual abuse, or incest. Right? Because the abortion law doesn't require any of those things. It just flat out says you have a right before viability unless it's an undue burden. That's Casey. So they keep mentioning rape, sexual abuse, and incest, but it's kind of irrelevant because whether Texas gives exceptions for that or not, I don't think influences the legal analysis. I don't think it's more or less illegal because of that. That's more like a political posturing than illegal posturing, it seems to me. If it prohibited medical necessity, that would be illegal posture. But I don't know of any law off the top of my head that would apply for legal analysis with respect to specifically rape, sexual abuse, or incest. So I think that's more political posturing than illegal posturing. If they grant standing here, I don't want to hear about standing doctrine. Okay, John. Let me make something clear because it might not be completely clear to the chat. I'm not sure exactly what you mean when you talk about standing doctrine. So let me talk about it two different ways. If you're referring to the United States of America having standing, yes, they have standing. There's case law on point, including a case called United States versus Texas from the 19th century. So yeah, the U.S. government does have standing to bring complaints against a state that is interfering with its laws. Now, whether or not that would be successful is a whole other set of problems. But yeah, there's case law on point with respect to standing. So the standing problem for the United States, I don't see an issue. Off the top of my head, at least, I don't see the issue. If, however, you're referring to the state law, SB 8, and it giving standing to private parties, so if you mean like SB 8 empowers like basically any random individual to bring a lawsuit, that's different because that's a matter of state law, right? When normally we're talking about standing, or like every time I've ever talked about standing pretty much ever, we're talking about Article 3 standing. We're talking about federal standing under the federal constitution. Like, can you go to federal court and sue? So normally when we're talking about standing, we're talking about federal standing because I do a lot of federal law. Right? So that's standing doctrine under federal law. But standing under state law is a completely different issue because different sovereign. Right? So if you're saying, well, I never want to hear about standing ever again if Texas can give random people who have no claim the ability to sue, I'm sorry, you're going to have to hear about standing some more because Texas, like who has authority to sue in Texas is ultimately a decision for Texas as a matter of state law. Texas can theoretically, as a matter of state law, unless it's going to violate some sort of fundamental due process, but unless you can trigger some provision like that in the Constitution, they can give standing to anybody. In fact, California does it too. Not as broadly as this, but they have a Private Attorney General Act. Now, in the case of California, their Private Attorney General Act doesn't take authority away from the state actors. So the state actors can also act. But yeah, they have a Private Attorney General Act, which allows people to... So it's not a problem because it's a matter of state law. So yeah, don't confuse the standing doctrines there. So yeah, standing for the United States versus Texas, no problem. Standing for people suing under SB 8, yeah, that's probably fine too, because it's a matter of state law. So yeah, it should be okay. Anyways. Okay, where were we? Specifically, SB 8 exposes federal personnel and grants liability to carry out federal obligations to provide abortion-related services to people in their care and custody of federal agencies, and interferes with federal contracts and grants with third parties who are obligated under their agreements to provide abortion-related services, but refuse to do so under the liability of SB 8. You can't interfere with the federal government. SB 8 also increased costs to federal agencies in carrying out their obligation to the extent civil penalties and awards are available. Yeah, that's not going to happen. No. In addition, it will be increased reimbursing costs under federal contracts with third-party providers. You can't interfere with the federal government. Finally, it will increase costs to the extent that agencies must incur increased transportation and other costs in their care to people outside of the state of Texas that are required under federal law but prohibited. Yeah, so I don't know if this is necessarily the right vehicle for this or not, but either way, this is right. Whether it's right here, probably it is, but I'm just thinking ahead. Possibly not. But if not here, then the first time someone sues a federal contractor or a federal employee, it's game over. So if not here, not today, the first time a federal employee gets sued, it's game over. Or someone gets sued over a federal contract, it's game over. So yeah, that's just completely correct. The state of Texas cannot interfere with the federal government doing shit. Yeah. Such impacts will likely be felt by numerous agencies and their personnel, including Department of Labor, which is ironic. Department of Labor. Office of Refugee Resettlement. Bureau of Prisons, Center for Medicare and Medicaid, Office of Personnel, and Department of Defense. Department of Labor Job Corps. It will interfere with operations, increase the costs of Job Corps, a program funded by Congress that assists eligible young people with completing high school education, preparing for meaningful careers, and obtaining gainful employment. Job Corps centers are primarily operated by private contractors that have contractual relationships, though some are operated by the Department of Agriculture. There are 4 job centers located in Texas, all of which are operated by private contractors. These are the centers. SB 8 will interfere with these relationships to the extent Department of Labor contracts require Texas Job Corps contractors and their personnel to provide abortion-related services prohibited by SB 8. As a healthcare thing? Is that enough that it's healthcare insurance paid by the feds? Let's ponder this for a second. So if the idea is they're required to provide it as part of an insurance plan, is that enough federal involvement? Not 100% sure on that one, actually, to be quite honest. It's an interesting question. The answer is probably yes, but I'm not 100% sure. Job Corps provides participant programs with room and board for up to 3 years, basic health care, living allowance, certain transportation, career. Shade says, hold on. Shade in chat said something like, unless Texas wants to interfere by refusing to provide any aid or support for immigrant enforcement. Well, Texas can. Yeah, it's commandeering doctrine. Yeah, the state can't interfere. The state can't interfere with the feds, and the feds can't make the state do shit. In terms of like its law enforcement doing shit or passing laws for that matter. So yeah, Texas would in fact be completely within its rights if it was so inclined to say, we're not going to help you, federal government. This is incidentally where the idea of sanctuary cities come from, right? That's basically sanctuary city 101. Like the sanctuary cities can't interfere with the federal government, but they don't have to help. So, yeah, there's like, we're just not going to help you with any immigration issues. Yeah, they can do that. It's commandeering doctrine. You can't do that. So if Texas wants to say we're not going to help the federal government with lots of stuff, then yeah, fine. No problem. They can't interfere with the federal government, and they don't have to help if they don't want to. So, yeah, no problem. That's fine. Bill said, are they required to perform services for ones not permitted or just overall? I don't know exactly what's going on here, so it's a little bit vague in this. Are insurance plans regulated on the state level? Typically, but federal government does have its own insurance plans for federal employees. Yeah, and I guess federal contractors too, although I couldn't say for sure, but yeah. Typically, but the federal government has plans for federal employees too that are regulated by the federal government. So yeah. So that could very well be. Requires Texas job contractors to provide medical services through provision or coordination of wellness, which includes access to medical, dental, and mental health services, which apparently includes abortion. All job center contractors incorporate by reference a handbook which was developed to provide all mandatory program operations reporting services. Thereby, Texas job contractors are contractually required to provide with requirements. This provides requirements with respect to mandatory services, including those related to reproductive health. Specifically requires contractors to ensure enrollees have access to pregnancy-related services, including information and services related to abortion. I don't know exactly what that means. What does information and services related to abortion mean exactly? SB 8 thus interferes with DOL contractual relationships by purporting to prohibit provision of contracted services and impose liability on contractors and personnel. This is not particularly well flushed out here, in my view. SB 8 thus directs the conduct of providers and constitutes direct regulation. The ACA also makes a requirement of plans for abortion itself. I don't think that's true. I think it made contraception mandatory, but I don't think abortion, if my memory serves correctly. Texas Job Center must also identify available community health social programs and make arrangements for transportation, so students in the program may access these resources. This includes family planning and reproductive services, transportation, to allow the enrollee to obtain an abortion permitted by federal law. Well, let's say this: if the health plans, if this is all coming as a result of a federally health plan, if this is a federal health plan, then I think you're there. I think you're there. That's enough federal action. So yeah, if all this is, if there's a federal healthcare plan, I think you're there. If it's, you have to pick some state plan that allows it, it's a little bit more tenuous. But yeah, so maybe not. It's just a little unclear in the complaint. To the extent that the law directs conduct of federal contractors and their employees, it's unlawful. That much is very true. Yep. To the extent that any of the Job Corps contractors is held liable for statutory damages, DOL may have to reimburse them for penalties, thereby increasing the cost of Job Corps. Federal contractors are entitled to reimbursement of costs necessary that are reasonable, applicable, and allowable. The costs of fines and penalties for failure to comply are likely allowable and recoverable, whether incurred as a result of compliance with specific terms. Okay, so maybe it's not. All right, so this is interesting and getting a little bit more attenuated, but probably close enough. So it now sounds like we're not talking about a federal healthcare program, federal insurance. It now sounds like we're talking about you have to pick some sort of insurance that's otherwise available on the market. I might be reading that wrong, but that seems to be what they're talking about. And so if they pick a plan and they get fined and the federal government has to pay, then that's probably too much. Yeah, that's probably too much. You can't get at the federal government indirectly. You can't interfere with the federal government, guys. That's basically the bottom line. The state can't interfere with the federal government. They can do what they get to do. The state gets to do what they get to do. Everyone's happy in federalism land, right? It's great. So yeah, if the federal government can do shit, you can't prevent them from doing shit. Deep concepts at work. So if the Department of Labor is going to have to start writing checks, no. No. Can Texas impose speed limits on federal employees? Good question. It's an open question. Have you ever seen a mail truck? Did you ever notice that a lot of them don't have license plates? Yeah. So, if the federal government really wanted to speed on those highways as a condition of their job, if the federal government required it, let me put it to you this way: if there's a federal motorcade somewhere and you try to ticket them, you're going to have a bad day. Yeah. Since the Department of Labor contracts with Department of Labor contractors require provisions of these services, damages imposed on the law and their staff acting within scope of employment are allowable and must be reimbursed. Thus, in addition to having pragmatic priorities function, DOL anticipates bearing the cost. Lauren Myers does give a very wonderful reminder to everyone. Thank you, Lauren Myers. Please remember to like the video. And also, you can be more like Lauren in more than one ways. Do you see that wonderful little green icon she has next to her name? And the orange icon A. Hedinger has next to their name? And the yellow icon MI has next to their name? Do you know how they get those wonderful icons? By being uncivilians. You can be an uncivilian too. It's true. Hit the join button. And if you can't hit the join button, from time to time, Streamlabs is providing you a link. It's about 10 messages back in your chat right now. So if you're on an iOS device and you say, I don't see the join button, no problem. Just scroll up about 10 messages, and there's a message from Streamlabs. where you can hit the link and you can join that way. For a mere 99 cents a month, you too can become an uncivilian. You get a cool little icon by your name, and I like you more. And if you haven't subscribed, subscribe. I try to give good legal analysis over here, for better or worse. We read that. If the job contractor, in an effort to avoid liability or ensure students can exercise their rights, attempt to meet their contractual or obligations would entail costs. Yeah, to the extent that this bill is imposing costs on the federal government, no. Just no. No, just all the no. Just straight up no. Just 100% no. The federal government has power to do stuff. And if they have the right to do stuff, the state can't stop them. Deep, amazing concepts. Separate sovereigns. For that matter, the state gets to do stuff, and the federal government can't stop them. Separate sovereigns, right? So then we get into whole kinds of things about what can the federal government do and what can the state government do, and when can impositions happen, and blah, blah, blah. But they're separate sovereigns. The federal government gets to do its shit. The state government gets to do its shit. Neither one can impose on the other, blah, 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 so forth and so on. So yeah, to the extent that you're trying to prevent, impose, hinder a federal employee or their contractor, or you're trying to cost the federal government dollar bill, y'all, just hell no. Just all the no, just straight up no. It's not happening. It's not happening. You can't do that. Office of Refugee Resettlement. This will impair with the across of the age regarding the transportation of unaccompanied children in their care who request abortions. I'll just take note here of the fact that refugees can get the federal government to provide them abortions, apparently. I just slightly query what their abortion rights look like in their home country. Consistent with obligations to provide care, they provide abortion services when requested and permitted, including cases of rape or incest, following judicial bypass procedures or parental consent, and subject to appropriations. SB erects manifestly unconstitutional restrictions, blah, blah, blah. Yeah, again, to the extent that this is inhibiting, prohibiting, interfering with, costing the federal government money, just no, just full stop, no, you can't do that. No, you can't do that, no. Did I see the Sixth Circuit ruled on Tennessee's abortion law? No, not particularly, but whatever. It won't let you complete the purchase, Carol. That's very, very sad. Try a different credit card. Bureau of Prisons. When a pregnant inmate elects to have an abortion, Bureau of Prisons is apparently required to facilitate that choice, which I guess kind of makes logical sense. Require prison wards to provide each care inmate with medical, religious, and social counseling to decide whether or not to have a baby. If they sign intent to abort, they shall provide for it. Again, yeah, to the extent you're trying to interfere with the Federal Bureau of Prisons, no, you can't do that. Center for Medicaid. Since states that participate in Medicare must cover various medically necessary procedures, such as physician services and inpatient, outpatient. Abortion is furnished as a service under one of these mandatory categories. I'll take your word for it. In accord with the requirement, states may not categorically prohibit the coverage of medically necessary abortions, which they are not, when federal funds are expended, including medically necessary provisions arising from rape or incest. See something in the Fifth Circuit holding Louisiana statute that categorically prohibits funding for abortions in case of rape or incest without regard to whether those procedures might be medically necessary. That's not quite the same thing. The Attorney General is misreading the law. So Louisiana passed a law that said you cannot have abortions for rape or incest. No exceptions, right? Medical necessity is a protected thing, right? So in the case of Louisiana, they said no for rape, no incest, period, flat out. That's not going to fly. Then the Attorney General says, where federal funds are permitted to be expended, including medically necessary abortions of pregnancies arising from rape or incest. If they're medically necessary, Texas doesn't cover that. So if they're truly medically necessary, the Texas law doesn't even attempt to cover it. So I don't see the problem. Although states are permitted to specify amount, duration, and scope of the service, they may not arbitrarily deny service of required service because of diagnosis. Conflicts with federal law by purporting to prevent administration of payment of services arising of rape or incest after fetal heartbeat. It's not clear that that's true. The way you summarize the law, and maybe you're misquoting it or maybe you're misreading it or something, but the way you're summarizing the law is that it's medically necessary. And abortion, and so limit states restrictive and inpatient is not sufficient. Yeah, so I'm not so sure about this cause of action for the Medicare Medicaid. It sounds like that's not going to work because Texas still allows medically necessary abortions as they must. So no problem. So I don't think that cause of action flies. Office of Personnel Management. Isn't rape and incest less than 5%? I think it's less than 1%. Yeah. A. Hedinger, I just want to, maybe you missed this discussion earlier, but we'll say it again for those of you who might missed it. Normally when we're talking about standing on this channel, we're talking about standing under Article 3. We're talking about federal standing. Whether or not you can sue in a federal court under federal law. So normally when we talk about standing, we're talking about in that sense, Article 3. So if for those of you who are wondering about whether a private person in Texas can sue for harm that hasn't occurred to them, it's a matter of state law. So we're under a completely different analysis than we would normally be on standing. And Texas is not the first in that particular respect, as we pointed out. California also has a private attorney general act. And as we pointed out, California's law is distinct, or different at least, because it doesn't strip state people of power. It just also extends it to private people. But at least the concept of private people having the power to enforce state law, I mean, California does that. And it's still in effect and not a problem. Now, yeah, there might be a problem here for other reasons, but standing is not the most obvious problem. It may not be a problem at all. There might be some sort of equal protection problem or something down the road. But yeah, there's no standing problem that's obvious because it's a matter of state law, and state law can create its own standing because it's sovereign. So yeah, it's distinct. So don't get too confused on that. Anyways, Office of Personnel Management, negotiating and approving health benefits made to federal employees. Each year, they negotiate for qualifying carriers to establish benefits. These negotiations encompass both services. Once OPM and the carrier reach an agreement, they are under a contract. Although under federal law, health plans under federal employees' health benefits may not provide for any services for abortion, except for medical necessity. Excuse me. OPM has entered into contracts with qualifying carriers that cover abortion procedures in permitted circumstances, which presumably are the medical necessity. Since SB 8 is inconsistent, it's not clear it is. Furthermore, SB 8 imposes liability for performing abortion disallowed under SB 8. It's not clear or even forming intent. Thus, a party could endeavor to pursue with a health plan that paid for an abortion. It's not clear there's a conflict with OPM. There might be, but it's not clear. So I'm not so sure about that cause of action. Defense Department. Intended to frustrate with Defense Department defense ability to provide abortion services. Federal law permits abortion services at DoD facilities in Texas. Well, they're DoD facilities, so you know how that's going to go. Provides these at military treatment facilities. Yeah, you can just kind of stop writing the argument at that point. Amazingly enough, the state government cannot interfere with a military doctor at a military hospital. No. Specifically, DoD's TRICARE programs covers abortion in case of rape or incest. Yeah, it's fine. TRICARE, blah, blah, blah. So, yeah, to the extent that you're trying to prevent the DoD from doing its thing, no. Not going to fly. Not going to fly. Yeah, the poll is over now because we're obviously covering this case. But yeah, we the poll's over, but the poll continues for some reason. The harms are traceable to the state. Yeah. Okay. So here's where we're sitting for a summary so far. The U.S. has standing. I don't see an immediate problem. There's original jurisdiction in the U.S. Supreme Court, which made me wonder if Texas can try to force this into the U.S. Supreme Court in the first instance. So there was a whole discussion about that. I'm not sure they want to, but could they theoretically? The government has defined state of Texas to include private parties, which makes me wonder, should I get service of process? The federal government is right that the private individuals are state actors. See Batman. I think we're there. The U.S. government is right to the extent that it is interfering with any federal activity and federal money. Some of those look more tenable than others. But to the extent it would impact federal employee, federal contractor, federal money, no go. So, yeah. So there's something there. And there's also a very interesting argument from Texas that Texas's law is actually compliant with Planned Parenthood. Texas, in its law, basically says, in so many words, that undue burden is an affirmative defense. So if there's undue burden, it's an affirmative defense, which means you win. Right? You win if it's an undue burden. Planned Parenthood versus Casey, by its own terms, speaks to undue burden. The federal case law on what is undue burden is not particularly clear. And I'm sure that Texas thought of every case on point and tried to write around the law that is clear to the extent. So they've tried to define what undue burden is. Might work. They say it's an affirmative burden to prove. They say it's an individualized analysis, which presumably, yes. I mean, you'd have to handle it. That seems fair. You know, whether it's an undue burden would be case specific, person specific. Yeah, that seems like workable. And they also say, the federal government tries to say, well, it's bad that the people can't claim undue burdens of others, but that seems fine because, like, you can only complain about your own undue burden, right? They're suing me. I can complain about the undue burden relative to me. I can't complain about the undue burden relative to other people because it's not my injury. So I think Texas has a colorable argument. It has a colorable argument that it is compatible with Planned Parenthood. So there's possibilities there. There's possibilities there. It's not to say it's winnable, but it's colorable. So yeah. These people are obviously state agents. But is the law workable under federal law? Maybe. And then, of course, Texas also thought ahead in its own law. Remember, because we dealt with the whole, like, there's a whole section at the end of the law that says, like, what is a court supposed to do? Right? So, like, severability. We sever every paragraph, every section from every paragraph, from every sentence, from every word. This legislature would have enacted the same thing minus that. Basically, we would have passed it to the maximum extent possible by law. So if you rule against us, then we still would go to the absolute limit that's possible. So they basically thought of everything possible. So they're like, yeah, we would have, so you can't, like, strike down the law as a whole, which was very, very clever. That might have been the most clever thing of all, actually, was in the remedy section. Might have been the most clever thing of all. Because Texas is like, okay, even if you strike us down, you can only strike us down within parameters. And then we are telling you affirmatively we would have gone up to the line. Like, you don't have to guess. And you don't have to say, oh, because this part of the law was struck down, other parts were struck down. No, Texas thought of all that. It's like, no, it's all severable from everything else. Everything is severable. All the things are severable. We would have passed the law, to account for all that. We've thought ahead, no problem. So yeah, the severability portions and the rewrite portions might be the most clever thing of all. So yeah, I mean, if you're a federal court, right? I mean, if you're a federal court, gimme, this can't influence a federal employee from acting. This can't influence a federal contractor from acting. This can't influence the government to spend more money. Easy peasy. Easy peasy. But on the undue burn thing, you'd have to think about it a little bit more. Especially because the undue burden case law is a bit of a mess. So, Texas is trying to define, Texas ultimately can't define it can't ultimately define undue burden because it's a meaning of federal law, right? So whatever undue burden means is a matter of federal law. Let's make that clear, right? Whatever undue burden means, it's a federal law issue because it comes from a federal case. So Texas can't define it, but they're giving a go at it. And if their definition is compatible with the federal definition, right? So just because Texas wrote it doesn't mean it's inherently invalid. It's only invalid if it conflicts with the federal law. So if Texas wrote a definition that is compatible with the federal law, then they're good. So all that stuff. So we'll have to see. It'll be an interesting analysis. All right, so let's read our causes of action. Supremacy clause for the 14th Amendment. This Constitution is supreme. Well, yeah, supremacy clause. We're doing both at the same time. A little weird. Okay. Doing both the supremacy clause and the 14th Amendment at the same time. So the Constitution is the supreme law of the land. We got that. SB 8 violates 14th Amendment because it prohibits war, because it goes against Roe. But does it, is Texas's argument. The Take Care Clause requires the president to enforce federal law. Fine. Texas has deliberately impeded the ability. Preemption. It's preempted because it's contrary to the 14th Amendment. Not obvious. It's preempted by federal law, including state and regulations, to the extent certain federal agencies are charged with it. Yeah, that for sure is true. Although preemption isn't exactly the right word, or not the right word I would use. Right? It's intergovernmental immunity. Preemption isn't quite the right word. Preemption is the word you use if the federal government has taken over what would normally be a state role. That's preemption. This isn't preemption because it's not taking over something. It's just defining its own thing. So I think preemption is the wrong word. Better is intergovernmental immunity, or federal or sovereignty for another. Sovereign immunity would be another way of putting it. So yeah, to the extent that this is trying to interfere with the federal government's employees, contractors, and spending money, no. Conflicts with execution of full purposes of objectives, violates supremacy clause because it's preempted under federal law. That is the worst cause of action I've ever read in my life. I mean, that's just bad. That's just bad. That's a tautology. SB 8 violates the supremacy clause because it's preempted under federal law. Who wrote that? It's a violation of the supremacy clause because it's a violation of the supremacy clause. All right, well, intergovernmental immunity, yeah. Prayer for relief, declaratory judgment, it's invalid, null, and void. I don't think you can get that far. Preliminary injunction is not impossible. The Fifth Circuit might have something to say about it, though. But the district court, right, because this is on a slightly different posture than this is under a different posture than the one that's already on appeal from the private one. Because in that case, you had a whole bunch of private people suing a whole bunch of private people. And it's like the standing issues are problematic because there's no harm to the private people. And who do you sue, right? So that's on stall for standing issues. But this one's different because the United States of America has standing. So I don't think there's a standing problem. So that's a question of doing the 4-factor test for the thing and likelihood of success on the merits. And the Fifth Circuit analysis could well be different too for reasons that we've talked about. So yeah. Can a federal employee break state law to the extent that, let's be careful here because you asked the question too broadly. Can a federal employee break state law? To the extent that their federal function requires it. Yes. Yes, to the extent their federal function requires it, yes, a federal employee can break state law. The state cannot interfere with the federal employee doing their job. Yeah, so to the extent it's part of their governmental duty, yes, they can break state law. No problem. Any other relief, costs, and other reward? Okay. So there's some good stuff here, but definitely some good legal analysis to follow. So we are looking forward to seeing if Texas has anything on the private. So we're looking to see if Texas has anything on the state actor doctrine that makes any sense. They seem like they're down and possibly out, but we'll give them a chance. See if they come up with anything that makes sense. As to the federal employees and stuff, I don't know what Texas is going to write. The most logical thing to write is waiving the issues, right? To the extent like that would be the most logical thing to do is not defend it on those grounds. Then you moot the issue, right? So it's like, yeah, the state just refuses to defend the law to the extent it interferes with a federal employee, federal contractor, or require the federal government to expend more money. Then you moot all the issues. So, I mean, that'd be the most logical thing to do because they're going to lose if they try anything else anyway. And then dealing with the undue burden as to private people and do that whole analysis will be an interesting fight. Yeah, good stuff. Good stuff. So let me see if there's some questions and try to answer some questions. Let's see. Where am I? All right, bot for questions. Complaint says that anyone enforcing the law is an agent in Texas. How accurate is this? We discussed that. I think they've got it. I'm cheering for Texas to win. I'm cheering for Texas. If Texas wins, other states will follow. Yeah, maybe, but you have to be careful about how it could be applied to other subject matter. Nick Rakita is of the opinion that it will be more difficult to apply to other subject matter. I'm a little bit more cautious. So Nick Rakita and I talked about this a little because, Nate the lawyer, because he got the idea from me, basically says, this can be easily applied to other subjects. Nick Rakita has said, especially when it comes to guns, he thinks it's much harder to apply. I think Nick is probably more right on balance, but I don't think he's as right as he thinks he is. So it might be a little bit harder to apply, but I'm not sure Nick is being sufficiently creative, and I don't say that to be unduly insulting. But it's like, yeah, it doesn't apply one for one, but the idea that could be applied in some of the mechanisms, I'm not so sure. So I'm a little bit more dubious and cautious of how this would example affect gun rights. So at least the way I've heard Nick tell the story, and maybe this is unfair, maybe the way I've heard Nick tell the story is, yeah, you just can't apply this to gun rights. And I'm like, I'm not so sure, Nick. I wouldn't bank on it. But maybe I'm being unfair to Nick, but that was my understanding of the conversation anyway. Joe said, but will federal law not prohibit federal monies from going to abortion? We discussed that. And, who knows? Joe's Matt said it wasn't clearly established I could throw the Joker off rooftop. Pretty sure that's clearly established one way or another. Linda says, why do they say this is a constitutional right when this is case law? Because the case law says it's a constitutional right. I mean, What about Medicare? We discussed it. Is this claim the federal government is paying for abortions? Wasn't that illegal? Well, we're dubious on that one, but yeah, maybe not. I don't know. Can the government deputize any private party involved in some defined abortions as a federal contractor acting on behalf, such that local law becomes a contract? Well, good question. Maybe. You'd probably need an act of Congress to do it. Although, the scope of things, what people can do in regulations gets creative. So, possible. Not the worst idea. Possible. Mantova says, I don't see any way Texas gets past the definition of undue burden in Casey. Yeah, the Casey itself doesn't really have a good definition of undue burden, and neither does any other case, as far as I am concerned. The case law is kind of messy and a little bit bric-a-brac. So Texas is giving it a go. And what's nice is also, again, in the severability section. So if Texas's definition of undue burden is wrong, then the law already says, well, go to the other definition, because we already said strike every word, sentence, blah, 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 right? So even if Texas is wrong on its definition of undue burden, it doesn't matter because we just readjust the goalposts and we move on. Maybe I missed it. Bill Anderson says, maybe I missed it, but wouldn't the Westfall Act handle federal employees in the suit since it moves to federal court? Absolutely correct. Absolutely correct. Yeah, the Westfall Act is 100% right. We didn't mention it explicitly, but yeah. So the Westfall Act is basically a law that says when a federal government official is acting in their official capacity, when you sue the employee, you're really suing the federal government. So under the Westfall Act, anytime you sue a federal employee for something they do in their job, the U.S. government's like, no, fuck you, no. And they're like, yeah, no, you're now suing the United States, so fuck you. So yeah, that's the Westfall Act. Yeah, you're 100% correct. We didn't discuss it explicitly, but yeah, every federal employee within the scope of their employment, if you sue them, you're really suing the federal government. And so then the U.S. government comes along and says, okay, this person's out. Now the United States is in. Sue us. Yep, that's the Westfall Act. Sure is. Manitoba says, let me quote Casey, always a good place to start, right? Let's quote the operative law. A state's abortion-related law is unconstitutional on its face if it will operate as a substantial obstacle to a woman's choice to undergo an abortion in a large fraction of cases in which it's relevant. There's so much there that's open to interpretation, as I'm sure you can appreciate. But yeah, it's like, why is the picture so dark? Is it really, really dark? Hold on. Well, I do have the f-stop really, really low. So it's not bringing as much light as it would, but is it really, really dark? I could change the, I'm unable to tell. I could put on some light or something, or I could just change the aperture. But let's just keep it the same right now, so you can deal with Uncivil Law After Dark, and I'll change it later for a different stream. How about that? Ask me questions. Ask me any questions other than will you fix the camera? No. Freedom of speech rights? Yeah, absolutely. For facilitating freedom of speech, yeah. It's like this law may not be able to be applied one for one, but it's the same exact problem. Ask me anything. Ask me legal questions. Isn't there a parallel to the Second Amendment with New York City creating undue burden? Yep. Yeah, there might be. Again, you may not be able to take this and just lift it and replace the words abortion with guns, but there's something there somewhere. Yeah. Ask me anything. You look red and the room looks green. I suppose you're right. Hold on. Take away the very past part of me. Ooh, darling, please don't go. Well, it's interesting that it is green. You're right. It is green in the camera. I wonder why that is. If I turn off the color grading, how much does it change? It changes quite a lot. Okay. Well, there's the color grading gone. Next question. Do you think the abortion bill in Texas will stand up? Hard to tell. It depends a lot of the analysis. Hard to tell. Texas has colorable arguments. Hard to tell. Can a person trespass in a public library? Yeah. Can they ask him to leave with no reason? Well, maybe. I mean, with no reason? Well, let's put it this way. They probably can't ask you to leave with no reason, but they probably don't have to tell you the reason. They probably need a reason. Like, they can't just exclude people for the hell of it because that'd be arbitrary and capricious, and the government can't do that. So they can't just exclude anyone for the hell of it, but, if they have a reason, and they probably only need a rational basis, So, yeah, you can trespass in a public library. Yes, they can ask you to leave for probably many reasons. Craig asked, Does your offer to sue Batman extend to the Bat Lady of Wuhan? Absolutely, man. Because then I can get those Fauci emails. It'll be great. Because fluorescent lighting is green. There's no fluorescent lighting in this room. There's LED lighting, but there's no fluorescent lighting in this room. Well, that's not true. Well, there's no fluorescent lighting on in the room. What was your favorite part of today? You mean just generally? I like talking to you guys. I like discussing law. And I like law that makes me think. This law makes me think. Because SB8 is technically clever. It's technically brilliant. And, trying to analyze this case from the U.S. government, it's like, okay, let's spot problems. It makes me think. I like this very much. It's one of the reasons we'll probably be covering it for a while. Because the private case probably might not go anywhere, but this case has better potential. And we'll learn a lot along the way. So why not? We'll cover it forever. We'll learn a lot of stuff. It'll be very informative. Can Biden mandate the vaccines? Good question. I don't know. They're trying to do it for federal employees directly. And they're trying to do it for any employer with more than 100 employees through an OSHA requirement. I'm dubious on both. I don't believe outside. Oh, now for military, of course, military is in a whole different category. I don't believe, and someone will correct me if I'm wrong, that the federal government requires its employees to have vaccines or proof of vaccines otherwise. So this might be a first. I'm not sure. Yeah, I'm not sure the federal government requires vaccines or proof of vaccines, but maybe they do. Someone can correct me. So I'm not so sure about that. Can you count like we're closing early as a reason? If they're in fact closing early, first, yeah, sure. Why not? I mean, you probably don't have a right for them to be open until the hours they state. So like, yeah, if the library is like quiet and stuff and like, yeah, we're going to close a little early. Yeah, that's probably a sufficient reason. As long as they're actually closing and kick everyone out, that's probably fine. Is it more brilliant or more scary? Well, it's a little bit of both. If Texas were just the state that once a harpy detected its life, that wouldn't work. Yeah, that doesn't work. It doesn't work. I mean, the way that Texas has done it is more clever. Yeah, Batman as QI, we've discussed that. Batman's going down. Yeah, the army, in fact, does. I mean, but it's the army. It's the military. So, yeah, they get all kinds of vaccines. How's the vaccine mandate interact with collective bargaining agreements? That's a very, very good question. And a lot of police unions, to my understanding, well, defining how you mean a lot, at least one. How about that? At least one police union has raised the issue. I think in New York, maybe. But yeah, there's an issue with collective bargaining agreements. There's an issue with autonomy. There's also an issue with mandating someone inject something in their body. There's issues that are colorable. Yeah, you work at a federal building. They want us to fill out a form saying we take the vaccine. I saw the old form. They have a new one. The old form, which existed like prior to today, said either that you took the vaccine or the old form, which I saw, you said, yes, I took the vaccine, or no, I didn't, or I declined to answer. And if you said no or I declined, then you have to mask and do some testing requirements. But it didn't, at least the old, I don't know if there's a new form. I doubt there is very much because there hasn't been, they just announced it. There hasn't been a follow-on yet. So the form that exists right now says, do you have a vaccine? If not, then mask up. But yeah, I'm not sure about the new one. Save Mars says the feds were saying this interferes with them by increasing their costs. Would not giving them aid also increase the cost? I don't understand the question. Oh, you mean for the state government? Oh, yeah, but they don't have to do that. Yeah, no, that's fine. It's one of those things about federalism, right? It's one of those things about like the state government gets to do shit and the federal government gets to do shit. So yeah, with the state government not helping the federal government increase their costs, yeah, but at least in that case, the state government gets to say no. So like the law's complicated. Like everything has rules upon rules upon rules. So yeah, it's like yeah, would a state saying we're not going to help you with the immigration or whatever, would that increase federal government costs? Yeah, can the state do that? Yes. Yeah, that's fine. Yeah, we're not gonna enforce your law. Screw you. We're not gonna help you enforce your law. Screw you. Yeah, does that increase the federal government's costs? Yes. Can the state do that? Yes. Is it legal? Yes. That one's okay. Do you think freedom of religion will be able to exempt the vaccine? Good question. And also because of federal law, like the nature of religion, right? It's like they can't. The government can't. The government can't determine if a religious precept is true. They can determine if you actually believe it. But if you say, yeah, maybe, that's bodily autonomy. Bill Anderson says, nothing to me. Planned Parenthood versus Casey preserves the bright lines at viability. Yes. But avoids defining that. That's true. Asserts that viability is when it becomes life. That's correct. The line is, yeah, so then when we try to define viability, I think, because what is the record for the most premature baby? Hold on. 22 weeks and change. $131 days. Do you want to convert that into other numbers? Now I have to find out what that is in like months and weeks. Well, what's 131 days and weeks? Uh, 18. 18.7. I didn't really, yeah, I thought it was 22, but apparently, am I reading this right? 100, wow. $21 weeks and 2 days. What's the exact number here? Hold on. Now they're saying 131 days. And then this other article says 21 weeks. Which is it? 131 days. Okay, so there's a conflict in the articles. Because some are saying 131 days, which is 18.7 weeks, and then some of them are saying 21 weeks and 2 days. And then this article says both. Anyways, so I think basically you could get away with a law defining the viability at 20 weeks. There was a lot of states playing with the 20-week language, and given this especially, I think you could get away with 20 weeks. Yeah, or at least you could get away with abortion after 20 weeks. So I think you could get away with that if you want to ban all abortions after 20 weeks. Yeah. And this is one case that's enough. Why not average common? Well, I mean, here's the argument that you would try. Like if you wanted to go that way, right? You would say, we want to protect all life that's viable. Right? We want to protect all life that's viable. And at least we have one case where it was proven to be viable. And The doctors gave it 0% chance at the time, apparently, right? So there's no, presumably there's no way to tell a priori if the 131-day baby will survive or not. There's no way to tell that in advance. I guess. They gave it 0% odds, right? So, if our interest is preserving viability, and now we know that can be viable, and we can't tell the difference, right? So that's the argument. It worked for. Should work, I think. What's penalty for possession of a counterfeit Vax card? Okay. All right, so let's try to answer this intelligently. What's the penalty for possession of a counterfeit Vax card? All right, let me put to you this way. Under federal law, there is a potential 5-year penalty for forging a government seal or logo. So, for example, on authentic CDC, on authentic cards, on authentic Vax cards, you may notice, usually in the upper right corner, there is the logo for the CDC. So if you were to put the CDC logo on a document yourself that was unauthorized, you'd be violating the federal law for putting the logo on the document where it doesn't belong. You can't replicate the logo. How about that for an answer? What do you consider viable? Well, viable by definition means it can survive. Either viable by the court case means it can survive either. It can survive outside the womb with or without artificial support. So that's with or without artificial support, it can survive. So that's the current definition of viable. The Church of Satan has made abortion intense. I know they're trying. Yeah, I don't think this will work for Church of Satan, at least under the current case law. Right, under the current case law, under Lemon versus Kurzweil, which still technically is good law, although even the Supreme Court's had questions with it, but it still is the good law for the moment, right? A burden that affects everyone equally is not a problem for religious freedom. So you can't make religious burden worse than a secular counterpart. That's a lot of the cases we saw, for example, for a lot of the lockdowns, and where they said you can't attend churches and stuff, or attend even religious private schools. We covered 10 cases of that on my channel, right? They were making attending religion harsher, or attending a religious school harsher than the secular counterpart. But as long as you're treating everyone equally, under Lemon versus Kurzweil, it's fine. So you just need intermediate scrutiny. So yeah, the Church of Satan trying to make it a religious precept, I don't think really works, because they're treating everyone exactly the same, whether they're religious or not. So it's not a burden on religion as such. So it should. I applaud the Church of Satan for its endless creativity, but no, I did I did particularly get amused when the Church of Satan. There's been some great cases with Church of Satan. My all-time particular favorite with Church of Satan was there was a school which had this, they gave it a name, and I forget exactly what the name was. They called it this mailbox thing. Okay, long story short, you could give kids something to put into their backpacks. They gave it a fancy name, private individual could give things for the kids to distribute to put into each other's backpacks. They called it the mailbox. They gave it some sort of fancy mailbox. It was, let's put stuff in private mail, in person's backpacks. Okay, that was the thing. This was for elementary school. This is kindergarten, first grade, second grade, something like that. It was really young kids. All right, and the school, as part of this program, had a no religious stuff provision, right? No religious stuff. Okay. So the Christian churches sued. And they made the argument that, well, you're unduly burdening religion, which is correct, right? You are allowing all this secular material. You're unduly burdening. You're making the religious material worse. First of all, you have to decide if it's religious or not. So, and second of all, when you do, you're treating it worse than its secular counterparts. You can't do that. Right? That's Lemon versus Kurzweil, right? You can't do that. So the church, or apologize, the court said, school, you have to distribute the Christian literature, which in this case I think was a flyer for like a vacation Bible school or something like that. So then the Church of Satan comes along and says, we're going to distribute Church of Satan coloring books. Coloring books with like the goat and the pentagram and all kinds of shit. And it was the greatest case ever, because then the Christians sued the Church of Satan. It was the greatest case ever. All the Christians went, no, we can't allow that satanic stuff in our backpacks. We're going to sue you. And the court's like, did you not read your own decision? Did you not read your own decision? The one that said that you can't unduly burn religion. Remember that? Remember how much you were cheering for that? Did you not read your own case? Right? And so then the school just got completely rid of the program altogether to avoid the problem. But it's got to be my favorite Church of Satan case ever, with the Christians suing, saying, you can't stop us from giving those kids information about the vacation Bible school. You can't burn our religion. The court says, you're right. And the Church of Satan says, coloring books. They say, you can't distribute that filth. Court, you got to stop them from distributing it. It's satanic. It's got to be my favorite case ever. But alas, I don't think any of that's going to apply to our present circumstances. Jonah says a nurse could probably get a legit copy and just put fake dates and doses. Well, if you have a nurse doing it, at that point you're forging business records. So I wouldn't recommend that. So yeah. Does that mean under Lemon requiring vaxxers would be okay? Under the current Lemon test, yes. There are other issues though. But as religious exercise, but the law, at least, well, let me put it this way. Apologize. Lemon versus Kurzweil says you can't treat religions worse. It doesn't say that you can't treat religions better. So if you want to give churches a special status, it's okay. This is incidentally like why churches have tax exempt status, right? You can't burden them, but you can give them benefits, because then it's not a burden on religion. It's hard to suppress religion when you're giving them benefits. So, so under the vaccine mandates, then the law as it exists right now allows for religious exemptions. And you can allow for religious exemptions because then you're giving religions a benefit, which is okay because you're not burdening them. So it's okay for the law to give religious exemptions as long as they give it to all religions. That's fine. Lemon has nothing to say about that because you're not burdening religion. It's fine. Bill says, I don't think the state is allowed to statutorily declare viability. I'm not sure any state has, and to the extent it has, I'm not sure it's ever tried to declare it in a reasonable way. But let me put it to you this way. If Texas came to me with that bill, I'd try to defend it. I think it's doable. How can one sue without firsthand knowledge of the abortion? I don't know, rumors, innuendo. Facebook? People post all kinds of shit to abortion on Facebook. Do you think that people post their abortion on Facebook? Yeah. Facebook. How about that? Falsifying data can be a crime, yes. Have multiple courts declared? Bill, you might have me on this one. Have multiple courts declared that a state cannot statutorily determine if a fetus is viable? You might have me on that one. I'm not the expert on all the laws. So you might have me on that one. If that's precedent that's right, then you might have one on me. You might have one on me, Bill. I should check out your channel. What do you cover anyway? Let's check out Bill's channel here. With the check mark. Fancy check mark. What does Bill cover? Let's check out Bill's channel. And now I have to find his channel. I want to find channels, please. Bill Anderson. Oh, you're a musician of some kind. That's cool.
Get ready for.
Oh, you have 2 million views. How many subscribers do you have? Is that you? Are you the musician?
Get ready for.
I don't know. I'm just confused. Yeah, then it comes as now, how are you verified? Yeah, that's the next correct question. How are you verified with no channel, Bill? How does that work? How are you verified with no channel? Carol Lucy. Save Mars, I will just point out that attempting that not only is breaking a law a crime, but attempting to break the law is a crime. So your suggestion of replace CDC with CBC might be viewed as an attempt under the federal law. Just before you get too clever there. How are you verified? What is the secret to verify? YouTube used to have different rules. Oh, so your account is so old that it doesn't. All right, that's fine. Account is older than dirt. All right, that makes sense. Yeah. All right. So, anyways, I'm going to sign off for now. So this has been a very, very educational video. I hope you enjoyed it. Hope we learned something. If you've been enjoying this video, please remember to give it a like. If you're not subscribed, please subscribe. And did you know for 99 cents, you too can become an uncivilian? That's true. You can help support the channel and help support streams like this where we try to learn things and try to better our legal knowledge. That's always fun. I hope all is well. Till later, my friends. Cheers and goodbye.